Recording in progress.
Bismillahirrahmanirrahim. We were doing this chapter, and the name of this chapter is Sources of Law. Right? We were halfway through this chapter, and we had stopped till doctrine of judicial precedent. Any questions still here, Kinza?
No, ma'am. Everything is clear.
Okay. Can you hear me clearly?
Yes, I can.
All right. Let's begin. Doctrine of judicial precedent. What have you understood till now? What is it? What is precedent? What is judicial precedent? We had a brief discussion in the previous class. So what's your understanding till now about this?
Exactly. This is actually about the systems we were discussing.
It's a source of law. It's a source of law. Law aaya kahan se? From where are we getting the rules of making the law, of creating the law, or what are the
history
principles
of law. Yeah.
setting the law? So this is one of the source. This is one of the source. What kind of a source is this?
Sorry, what kind of a source?
Yes, explain it.
It's just a regular course which people used to follow before, that whatever it used to be in a history, they used to follow that.
Okay. So whatever cases have passed in the past, have gone through in the past, and judges have faced those cases and sorted those cases and given a judgment on those cases have been recorded somewhere. It has been recorded somewhere. Now, when you look back through those cases to find a similar case as yours that you are dealing with today, so you're looking back. Okay, you're looking back at the previous cases, right?
Yeah, right.
That is known as precedent. That is known as precedent. Judicial precedent, the judges have solved those cases.
Yeah.
Okay. So judicial precedent. Now, what is doctrine of judicial precedent? What is doctrine of judicial precedent? Please read.
The system of judicial precedent is based on a fundamental feature of English law, which is that principles of English law do not become operative through the lapse of time. Now they are telling us that as the time is passing, it's not changing. The principles, the main law, like you gave example last time, that the principle of gravity, it cannot change. Just like that, the principle English law, whatever has been made by the judges or the history made it, it cannot be changed. It is still in law and it is still consistent.
The system of judicial precedent is based on a fundamental feature. It's based on the fundamental feature of English law. That means there is a fundamental line just underneath the English law system, which English law follows, which UK people follow. There is a basic feature, basic understanding, basic principle, whatever you call it, fundamental feature, which is that principles of English law do not become inoperative through the lapse of time. Can you give me an example?
Like, for example, if somebody is giving a bribe, so later on, you can't say that after 10 years, that's okay, the law has been changed. No, if it's wrong in the book of law, then it is wrong. It's not going to change after the time.
Exactly. If it is wrong 10,000 years ago, it will remain wrong 10,000 years after. The time, no matter how much time has passed in between, the principle, the feature will remain the same.
That's right.
बुराई बुराई है, अजल से अव्वल से अजल तक रही. ठीक.
Some new laws can come in, like if we talk about cybercrime, now IT is also improving a lot. Some new laws can come in, but the previous one, the laws, they will remain the same.
No. It's not about the law. It's not about the law.
It's about the principle.
About the principle. कानून है कि स्कूल्स जो है 8 बजे लगते हैं, ये कानून है, ये लॉ है, बट इसके पीछे प्रिंसिपल क्या है?
अर्ली टू
पीछे
राइज वाला.
प्रिंसिपल ये है कि सेव योर डे, you have that
Yeah.
number of hours, we have to train or discipline our children to wake up early, so this is a discipline के लिए ये सब हो रहा है, ये लॉ रखा है, ये रूल रखा है.
Okay.
So the principle is not going to change. The laws might change or might be, twisted or
A
molded
bit different.
according to
Yeah.
the situation, according to the generation, according like cybercrime. If you're talking about cybercrime, what is cybercrime? Kinza, what do you understand when you say cybercrime? What kind of a crime are you expecting on cyber, on internet?
Cybercrime is a kind of crime whichever is happening like on a internet. If somebody is hacking me up, or maybe if I'm like somebody is using my pictures, they're using my videos, so it's all coming in the
You just
underlined
said
cyber.
hacking. What is hacking? What is hacking? If
Uh,
you just use another word for hacking,
Hacking is like somebody stealing my
stealing,
email, my privacy.
theft,
Yeah,
right?
theft.
theft
Yeah,
theft बुराई है. theft चोरी करना, किसी और का माल गबन करना, चोरी करना बुराई है. And that's a principle. That's a principle. That was a burai when Adam was created, and that's still a burai. And after 15 years, it will remain that a bad thing to steal. You can't change
right.
that. But the law will change because it's now happening on internet.
Yeah,
Punishment might change a bit. The
that's
situation
right.
might change a bit, but the basic principle is the same. Are you getting
Okay.
the point?
Yes, I'm getting it now.
Laws are different, two different things. Okay. Now,
Okay.
if- all right. Now, which is that principles of English law do not become inoperative through the lapse of time. So the time does not matter. Fine. Moving on to the next terminology. Please read.
Uh, the doctrine of consistency following precedent is expressed in maxim stare decisis, which means to stand by a decision. In any later case to which a legal principle is relevant, the same principle should, subject to certain expectations, be applied. A precedent is a previous court decision which another court is bound to follow by deciding a subsequent case in the same way.
Right. What are you understanding by this entire paragraph?
They're saying that whatever decisions we have made, whatever principles we are following, we have to be consistent in it. It's not like somebody is pressurizing me and now I'll say, no, this is not wrong. This is right. You can do it because you're doing it on a maybe like for example, if I'm stealing something and I'm giving some of the money to the poor with that money, so it's not. I can say that see, I'm not using the whole money on my own self. So the rules, the whatever the previous decisions has been made about about that case is going to be the same. It will not change. It will not. You have to follow whatever the previous judges has done with that case. Maybe you can change a bit according to the situation, but the main core should be the same.
Exactly, exactly. Doctrine of consistency means that every time a case comes up in front of you or any judge, he must decide or he must follow the basic principles on which, on the basis of which the previous cases were decided, on the basis of which the previous judges decided, right? So you
Yeah,
have to maintain that consistency. नहीं तो कोर्ट से एतबार उठ जाएगा कि अरे
true.
10 साल पहले मेरे बाप का ऐसा केस आया था और जज ने तो ये फैसला सुना दिया था, और अब वही सेम केस मेरे पोते का आया है, तो वो जज बिल्कुल ही अलग प्रिंसिपल बता रहे हैं. ठीक है,
True.
इट शुड नॉट बी लाइक दैट. इट शुड नॉट बी. इट्स अ स्टैंडर्ड. They have to maintain the standard. So that is doctrine of consistency. Now, what are they saying? Let's read it once again. The doctrine of consistency following precedent is expressed in the maxim stare decisis. Maxim stare decisis basically is a Latin term. Okay.
Mhm.
Now this Latin term means to stand by a decision. To stand by a decision. Like for example, we read the court structure, right, Kinza? We read the court structure. Court structure mein which is the first court?
Majestic.
Magistrate. Which is the
Yeah.
second court?
Crown,
County.
Crown County.
County.
Sorry,
Then
County.
Crown.
Crown.
And then High.
Then High Courts,
Then Supreme. Okay.
Supreme.
Now, for example, there is a client. Okay. There is a client. This client or this claimant, this claimant, he approaches the magistrate court. Okay. He approaches the magistrate court. Magistrate court hears the case and says, okay, I gave a decision X, Y, Z. And this decision is based on a principle A, B, C. Okay, and magistrate has given the right judgment. Okay, it has given the right judgment. It is not wrong. The correct principle, correct judgment passed. But the claimant is not satisfied. The claimant says, no, 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 I don't agree. I don't agree. So what he will do, he will go to the county court or he might
Yeah.
go to the crown court. Okay.
Yeah.
Now the judge of the county court or the crown court, what will he do? Or what should he do?
He will first look into the previous court history, whatever the decisions has been made. He'll review all the stuff.
He would first look at the case, listen to the claimant, why is he not satisfied, and then he would investigate कि magistrate court ने आखिर ऐसा क्या फैसला सुना दिया कि वो satisfy नहीं, right? And when he will
Right.
look into the case, the judge will see that okay, the principle is right, the decision is right. That means that there's some problem with the claimant, or he is expecting something different. Now the
Yeah.
judge, just to सिर्फ अपने number बनाने के लिए, just to make himself the hero,
Yeah.
or just to satisfy the claimant, he cannot change the judgment or decision because it's not wrong. He has to abide by the principle which
Okay.
the magistrate court is doing, and it is right. It is right. We can't deny it. So you have to stand by the decision made by your junior courts or made by your senior courts if they are abiding by the principles. If they are following
But
the
if you think that they were not right, then you're not supposed to stand by them. It's
yeah,
not always the
then
case.
you will look into the case again. You will look at the facts and figures, and you will definitely again proceed the case, the investigation. Okay, it will happen all over again, only if he has been denied the right justice. So in any later case to which a legal principle is relevant, the same principle should subject to certain exceptions be applied. All right. Now this is obvious, like, every case is different. Every
Yeah,
case
and
is
sometimes there are exceptions. It's not always the same every time.
exactly. Now, a precedent is a previous court decision which another court is bound to follow by deciding a subsequent case in the same way. I hope this is also clear now. कि
Yes,
जो
sir.
फैसला पुराने कोर्ट में या किसी 5 साल पुराने केस में सुनाया गया था उसकी वो किसी प्रिंसिपल की बुनियाद पे सुनाया गया था, and if that principle is right, the upcoming court which is facing a similar case, similar facts, similar case which requires the same principle, then it has to use the same principle and pass the similar kind of a decision, similar kind of a judgment. Okay.
Okay.
Now moving ahead, it's the same thing that we discussed here. Judicial precedent is based on 3 elements. What are those 3 elements? Now,
Reports, rules, classifications.
yes, please read.
Reports. There must be adequate and reliable reports on earlier decisions. Rules. There must be rules for extracting a legal principle from a previous set of facts and applying it to current facts. Classification. Precedents must be classified into those that are binding and those who are merely persuasive.
So precedent is based on three elements, and three elements are reports. Reports means, of course, the previous cases must be having
Yeah,
some reports, right? Which
that's
the
right.
current court is going to go through. And then he's going to see, okay, what was the principle, and okay, we will analyze, is this a similar case than the case right now in front of me? Then he's going to pass the same decision. Rules. There must be rules for extracting a legal principle from a previous set of facts and applying it to current facts. Very important. Very important. Kinza, मुझे एक बात, have you watched old dramas, PTV dramas?
Which one?
90s के 80s के जब नया नया टीवी आया था पाकिस्तान में, first time the TV was launched and first time there was only one channel, PTV channel. There was a time and drama आते थे. Have you watched any of those dramas in those
Yeah, I've watched Ankahi.
Ankahi and any other?
Dhoop Kinare, I guess. Dhoop Kinare. Okay, that's it.
So how do you find it different from today's drama or today's um, demonstration of the action and the acting and everything? Like, how do you find, what are the differences that you find over the period of time that you saw in that and how today's drama looks like?
If we talk about appearances, I think a lot of things were different. People were not, people were very simple and they were just focusing on the simplest things in the house, maybe nearby. And if you talk about now, they are more concerned about global things, glamour, artificial stuff, maybe.
Okay, okay. Let's watch. Let's just watch a small clip, okay? Let me share it.
डॉक्टर साहब दिस इज वही टाइम है
अस्सलामुअलैकुम डॉक्टर साहब।
वालेकुम अस्सलाम, तशरीफ रखिए। जी
डॉक्टर साहब, उन गोलियों से तो कोई फर्क नहीं पड़ा।
ओह, क्या भाई?
जी डॉक्टर।
फिर और क्या दवाई दें तुमको?
कुछ नहीं डॉक्टर साहब, मुझे जरूरत ही नहीं।
जरूरत है सलमा बच्चे, तुम नॉर्मल नहीं हो बेटे।
खैर ये बात तो नहीं बेगम साहब, असल में आप खामखा परेशान हो रही हैं।
मेरा ख्याल है डॉक्टर साहब मैं इसे न्यूरो फिजिशियन को ना दिखाऊं।
न्यूरो फिजिशियन तो नहीं बेगम साहब, अलबत्ता आप ऐसा करेंगे किसी साइकियाट्रिस्ट से मिल लीजिए।
डॉक्टर फिरोज से?
डॉक्टर फिरोज से या प्रोफेसर सलीम से या फिर डॉक्टर बदर से। वो अभी अमेरिका से आए हैं साइको एनालिसिस का कोर्स करके।
अच्छा अच्छा, डॉक्टर बदर वापस आ गए हैं।
जी।
तो डॉक्टर साहब फिर ठीक है, बहुत बहुत शुक्रिया। थैंक यू।
वेलकम बेगम साहब।
सलामुअलैकुम डॉक्टर।
वालेकुम अस्सलाम।
वो मिस्टर और मिसेस नईम आई।
जी जी भेजिए भेजिए।
अस्सलाम वालेकुम डॉक्टर साहब।
वालेकुम अस्सलाम, कैसा हाल का?
थैंक यू वेरी मच।
इधर आ जाएं। How are you, Mrs. Naeem? Oh, I am sorry.
डॉक्टर साहब वो ट्रैंक्विलाइजर्स हैं तो अच्छे, लेकिन कोई मुस्तकिल हल नहीं है उसकी।
अच्छे, my foot.
अब आप क्या महसूस करती हैं?
कुछ नहीं.
मेरा मतलब है कि वो पहले से कुछ फर्क महसूस किया आपने? How do you feel now?
I feel that I am stupid, selfish, hypocritical, egotistical, narrow-minded. कुछ और पूछ रहे हैं आपको?
प्लीज प्लीज मिसेस नेम हौसला कीजिए. देखिए देखिए वो मेरी बात सुनिए.
आपने गालिबन मुझे टेलीफोन किया था.
जी डॉक्टर साहब, बेगम वहीद.
बेगम, जी जी फरमाइए.
डॉक्टर साहब ये मेरी बच्ची है सलमा.
हाँ.
इसकी कुछ मुश्किलात हैं डॉक्टर साहब.
हर ह्यूमन बीइंग की कुछ ना कुछ मुश्किलात होती है बेगम साहबा. क्यों भाई?
डॉक्टर साहब ये सेकंड ईयर में पढ़ती है जॉन बेंजामिन कॉलेज में. अब वैसे अगर आप मुनासिब समझे तो मैं अलहदगी में आपसे बात कर सकती हूँ.
जी हाँ, क्यों नहीं, बिल्कुल मोस्ट वेलकम. आइए तशरीफ लाइए.
क्यों बेटे?
जी अम्मी जरूर.
आइए आइए.
डॉक्टर साहब मेरी ये बच्ची कुछ एबनॉर्मल है. इसके अबू तो सारा दिन काम काज में मसरूफ रहते हैं. उन्हें तो कुछ मालूम नहीं, लेकिन मैं बहुत परेशान हूँ डॉक्टर साहब. डॉक्टर साहब ये जो सलमा है ना, ये मेरे चारों दूसरे बच्चों से मुख्तलिफ है. मुझे तो इसकी समझ नहीं आती, बल्कि कभी कभी तो मुझे इससे डर लगने लगता है.
जी.
डॉक्टर साहब ये बोर नहीं होती.
जी.
कैसी भी सिचुएशन हो, कितना ही डल माहौल क्यों ना हो, डॉक्टर साहब ये बोर नहीं होती, इत्मीनान से बैठी रहती है.
ये फरमाइए कि पढ़ाई में कैसी?
पढ़ाई में या अव्वल या सेकंड. नेट बॉल की शूटर है, कॉलेज कलर मिला है इसको, हर्डल रेस में पहले थर्ड, 30 मरतबा अव्वल आई है. लेकिन डॉक्टर साहब ये अपने दूसरे बहन भाइयों से मुख्तलिफ है. मेरा ख्याल है इसमें कोई खराबी है शायद.
मतलब ये अंदाजा आपने कैसे लगाया?
आपको बता रही हूँ ना डॉक्टर साहब कि ये बोर नहीं होती अपने दूसरे बहन भाइयों की तरह या अपनी सहेलियों की तरह. मुझे तो डॉक्टर साहब इसकी बड़ी फिक्र पड़ी हुई है.
लेकिन फिक्र क्यों बेगम साहब?
बोर तो अनपढ़ लोग नहीं होते, जाहिल और कमाल. पढ़े लिखे लोगों को तो बोर होना ही चाहिए.
मगर क्यों, क्या वजह बेगम साहब?
इसलिए कि उनके पास इल्म होता है, अक्ल होती है, वो बुरे भले की तमीज कर सकते हैं. उनको पता होता है ये हमारा इंटरेस्ट है, ये नहीं है.
ये फरमाइए कि बच्ची को ये तकलीफ कब से?
शुरू से डॉक्टर साहब, बचपन से. और मेरे सारे बच्चे हैं माशाल्लाह, आला से आला खिलौनों से खेलते रहे, अच्छे से अच्छे कपड़े पहनते रहे. लेकिन इसको कभी ख्वाहिश ही नहीं हुई ऐसी चीजों की. छोटी सी थी तो चाबियों के गुच्छे से खेलती रहती पंघूड़े में पड़ी हुई. जरा बड़ी हुई तो एक ही गुड़िया से खेलती रही 6-7 साल तक. और अब
सुकिंजा, क्या देखा?
I think actually what you mean is like they didn't have much knowledge about it, because nowadays everybody knows child psychology and everybody has the knowledge of the main factors, human behavior and stuff. And at that time, the time was very simple and they were more concerned about the tiny bits.
Kinza, see, the thing is कि जब वो खातून पहली दफा गई, उसको कौन से मसले को लेके गई डॉक्टर के पास? What was the issue?
She was concerned about her child, that she's always happy.
Yeah, the concern about the child was that she is abnormal.
Yeah.
Right? That she is abnormal.
Right.
अब डॉक्टर को क्या लगा? डॉक्टर का एक्सप्रेशन क्या था?
He was recommending other doctors and he was also agreeing to the fact that she is not normal.
Was he agreeing to the fact that she is not normal?
Maybe that's why he was recommending other doctors. Maybe he was also convinced that maybe the girl has some major issues.
See, किंजा पहला डॉक्टर था, ठीक है? पहले डॉक्टर के पास जब ये खातून आई और उसकी कंप्लेन क्या थी कि डॉक्टर साहब आपने जो दवा दी है ना वो तो काम ही नहीं कर रही है. ठीक है, वो तो काम ही नहीं कर रही है, मेरी बेटी अब नॉर्मल है और उस पर तो कोई असर ही नहीं हो रहा. So this doctors, if you had watched it carefully, इसका एक्सप्रेशन ये था कि यार ये खातून अपनी बेटी को abnormal क्यों कह रही है. She doesn't look abnormal. She looks normal, but and she's not satisfied with my medicine, so he recommended another doctor.
Mhm.
Okay? When she went to another doctor, this doctor also had the same reaction. कि she is saying abnormal, her child is abnormal, but जब वो उसकी बेटी को देख रहे हैं तो उसको ऐसा कुछ नजर नहीं आ रहा कि उसमें abnormal क्या है. What did they do then? They go in the privacy. अलग कमरे में जाते हैं and then they have a detailed conversation, detailed investigation. कि अच्छा डॉक्टर इज आस्किंग द क्वेश्चंस. अच्छा आपको क्यों लग रहा है कि आपकी बेटी abnormal? Then she says, मुझे इसलिए लग रहा है क्योंकि ये बोर ही नहीं होती. Now the doctor is understanding. अच्छा ये
That abnormal is actually mama, not the daughter.
So फिर वो दूसरा क्वेश्चन करते हैं कि अच्छा आपको क्यों ऐसा लगता है कि वो बोर होती है, मतलब ऐसा क्या वो कर रही है. Then she tells the complete story that okay, my other children play, but she is never bored, she never complains, she is always mutmain and happy. Like what is this? And then she also says कि भाई पढ़े लिखे लोग तो बोर भी होते हैं क्योंकि उनके पास शौक होते हैं. But see, the whole story is coming out after the questioning from the doctor.
Yes.
Now he is better able to understand कि भाई मसला क्या है. And then he can better subscribe or prescribe whatever the solution he finds fit. Yes or no?
Yes, that's right.
Same way when किसी जज के पास एक क्लाइंट आता है, क्लेमेंट आता है अपना मुद्दा लेके, ओके, मे ये मुद्दा लेके ये क्लाइंट, ये डॉक्टर जज था, क्लाइंट उसके लिए सोल्यूशन फाइंडर था, ठीक है, और ये क्लाइंट आएगी तो डॉक्टर साहब ने जितने भी रूल्स पढ़ रखे हैं लॉ के मुताबिक, डॉक्टर साहब ने जितने भी कानून पढ़ रखे हैं बायोलॉजी के मुताबिक, मेडिसिन के मुताबिक, वो सब रूल्स को सामने रखते हुए कोई फैसला सुनाएगा.
Exactly.
अगर उसे रूल ही नहीं समझ आया हो तो उसको
तो
रूल
वो obviously questioning क्या करेगा? If he himself is not clear about the rules, so obviously there's no use.
Exactly. So he better be clear and देखो ये कैसे पता चलेगा कि डॉक्टर साहब को मेडिसिन क्लियर हो गई है या किसी भी जज को उसके रूल्स प्रिंसिपल्स थरोली मालूम है सिर्फ ग्रेड में पास होने से, अच्छे नंबर्स लाने से? क्या आपको लगता है ये बात की गारंटी है?
No, not at all.
Every person has a different way of looking at the situation.
And mostly it comes up with the experience. The more you deal with these cases, the more the more vigilant you get.
Exactly. But still there has to be a guide बुक कि भाई तुम गलत ट्रैक पे जा रहे हो, तुम गलत इंटरप्रिटेशन कर रहे हो रूल की, तुम गलत इंटरप्रिटेशन कर रहे हो किसी भी मेडिसिन की. तो दिस इज द वे टू इंटरप्रेट एनी सिचुएशन, दिस इज द वे टू इंटरप्रेट एनी रूल, बिकॉज सिनेरियो इज डिफरेंट. अब फर्स्ट करो मैं आज जज हूँ, ठीक है, आई एम द जज, आई एम सिटिंग इन द कोर्ट एंड आई गेट अ केस एंड आई से दैट ओके आज की सुनवाई मुलतवी की जाती है, ये अब हम कल अब आप लोग अपने मजीद एविडेंसेस लेकर आओ, देन टुमारो वी विल हियर द केस. व्हाट आई विल डू, आई विल गो बैक होम, आई विल टेक आउट द जुडिशियल प्रेसिडेंट, आई विल गो थ्रू माय सोर्सेज ऑफ लॉ एंड आई विल ट्राई टू फाइंड अ सिमिलर केस एंड आई विल स्टडी दैट केस एंड आई विल स्टडी दैट ओके ये मुझे केस मिला है 1800 का और ये केस लड़ा गया था लंदन के मजिस्ट्रेट कोर्ट में और ये केस के फैक्ट्स एंड फिगर्स मेरे आज के केस से सिमिलर है. उस वक्त 1800 में क्या प्रिंसिपल निकाला गया था इस केस के लिए और उस प्रिंसिपल के बेस में क्या जजमेंट पास की गई थी. सही. अच्छा, प्रिंसिपल था कि चोरी करने वाले के हाथ being standing in 2022, I have no clue that what was the situation in 1800.
That's right.
What was the scenario? What were the norms of the society? What was the mindset of the people?
Yeah.
I have no idea. It may happen that I might interpret it in the wrong way. Or it even may happen that that rule or that principle was applicable for that time, but in today's time I have that authority to maybe make it more moderate, or maybe make it more acceptable in today's time.
Yeah. Because at that time, if somebody is stealing up the hens, so that was a very big crime. And nowadays, it's not that big because the society has changed a lot. It's a lot modern now and stuff. So obviously, it's not going to be the same punishment for all the time.
This is just an example. There can be
Yeah.
a lot many principles that in those days it might mean something else, but in now today's
Yeah.
time.
Again, the same thing that you were saying, that the principle is going to be the same. The rules, the laws, they can vary with time.
Yes, exactly. So it is very important. It is very, very important, Kinza, that a person should know how to take out the interpretation. अब देखो कुरान एक ही है, but हर कोई अपने अंदाज से इसको translate और interpret करता है, right or wrong. There are so many
True.
tafsirs of Quran. So what is it then?
That's
Like एक शख्स बोलता है कि भाई ये तफसीर इसके ये मायने हैं, इसकी ये डिटेलिंग है, और दूसरा शख्स बोलता है नहीं ये तो कुछ और है. So whom should
exactly.
I go with? Being an audience, being a public person, whom should I go with? Like, should I listen?
And once we'll be having a lot of knowledge, so then we won't be influenced by anybody else. Then we can follow the right person, right path. So
Exactly.
I think same is the case with the
These
judgment.
guidelines have been given by UK, and they have also set some rules कि अच्छा अगर आपको किसी चीज को interpret करना है तो किन किन चीजों को देखना होगा आपको. What is the criteria of interpretation? So you have to keep those things in mind so you don't go wrong. Okay, so that's what it says. Classification. Precedents must be classified into those that are binding and those which are merely persuasive. Now, there are two types of classifications. One, two. Precedents, old cases. Let's make it easier. Old cases. Precedents, old cases must be classified into those that are binding and those that are persuasive. यानी कि पुराने cases को दो तरह से we need to classify. One, binding, जिनका कानून पास हुआ judgment पास हुई हुई is binding upon the upcoming people for the future courts. You cannot change even a bit. You have to follow as it is. So there are some kinds of cases which you have to follow the principle, the law, everything, the decision, the penalties as it is. You cannot change. And there are some other cases where it is persuasive. You can change. There is the room to change, to modify, to give a decision according to the situation. Right?
Right. Okay.
Now, coming to next. There are several major series of law reports bound as annual volumes. बहुत सारी law reports को जब आप bind करके, like you get past papers for any question, for any subject. This is kind of a past paper for the lawyers. Law reports as annual volumes, past cases.
Okay.
Okay, this denotes. Okay, now there's a case. Now we're going to study a case. But before we get into the case, let's just see. What does a full law report include? A law report includes, Kinza, read.
As regards content, a full law report includes details of the following: name of the parties, court in which the case was decided, judge or judges, date of hearing, points of law established, earlier cases
Cited.
cited, previous history of the legislation, facts, litigation, facts, names of counsel, and their arguments, verbatim text of the judgment, order of the court, whether leave to appeal was granted, solicitors, reporting barristers.
So these are the things which, this is the content which must be there in the full raw law report. Okay, next.
It is only decisions of the high courts in important cases, the High Court, the Court of Appeal, and the Supreme Court, which are included in the general law reports.
So now the thing is that not all cases that come in the higher courts are published in the general law report, right? So which ones are published? Only very
The most important one.
Okay, now let's just read this because this is important for your knowledge. Exam focused one. Please.
Students are often perplexed as to how much they are expected to memorize of cases referred to in textbooks. By the far most important aspect of a case for your examination purpose is what is about, that is, the point of law which is illustrates or establishes. This is a knowledge that you must apply when answering exam questions. Knowing the fact of some cases is helpful, not least because exam questions may well include scenarios in which the facts are based on a well-known case.
Okay, so the thing is here, Kinza, that we will be studying a lot of cases. Okay, throughout the F4 syllabus, we will be going through a lot of cases. But studying those cases does not mean you have to learn the names of the cases. Okay,
Yeah.
there would be few cases that I would be going through in the class, and there would be many cases that I would ask you to go through yourself. Okay, but for exam point of view or from exam point of view, there is no need to learn the names of the cases. Only you need to remember the case and the law behind it. Because we need to understand that what are the basic laws, what are the basic principles or rules behind taking any action or taking a decision. So that only is important. No names, facts, years, nothing important. Okay. As regard to the case. Now, moving ahead, the doctrine of judicial precedent is designed to provide consistency in the law. Four things must be considered when examining a precedent before it can be applied to a case. All right. What are they saying? They are saying that there must be consistency in law, and there are four things that you must consider. And what are those four things? Read.
A decision must be based on a proportion of law before it can be considered as a precedent. It may not be a decision on a question of fact. Like if you're confused about it, if there's a question you are not sure about it, then it cannot be a decision. So you have to be very clear about it first.
First decide whether this particular case is a precedent or not. क्या ये ओल्ड केस के जुमरे में आता है या नहीं, या ये कोई केस था भी या नहीं, या ये बस पासिंग बाय एक सिनेरियो था. So you have to decide that whether this particular case that you're studying or that has come to you is a proper case, or is it just a passing by incident, or is just a breaking news. What is it?
Okay. It must form part of the ratio decidendi of the case.
We will understand this shortly. Next.
The material fact of each case must be the same or comparable.
Each case must be the same or comparable. Okay, next.
Yeah. The preceding court must have had a superior, or in some cases equal status to later count court, such that its decisions are being on the latter court.
Binding on the latter court. Like now we just studied that there are two categories of cases, two categories of precedents. One is binding and the other is persuasive. So first you have to decide whether this particular case is a precedent or not.
Okay.
Second, you need to decide whether it is having a ratio decidendi or not. We'll understand this in a minute. And the third thing that you have to decide is that whether this case has happened in a junior court or in a senior court. You are a particular court, na? You are a judge of a particular court who is referring to the judicial precedent for your own case. So if you are belonging from Crown Court, you have to, and you're looking at a case which happened in Magistrate Court, you have to see whether it is a junior court or a senior court. If it is a junior court, then the decision is not binding upon you. If it is a senior court, then it may happen that it is binding.
Okay.
Okay, that is the third thing that you're going to see, that is the status of the court. Status of the court. Then, and the last thing.
You mean that if my last court was High Court, then of course I don't have any other option, maybe going to the Supreme Court later. But if it's a senior court, then obviously then there is no use to appeal.
And then you also have to make sure that the material facts are the same of your case and the case which you are referring to, the material facts. So these are the four things which you are going to consider definitely before relying upon that case, relying upon the judgment of that case. Okay? These are the four important. Next, ratio decidendi. What is ratio decidendi?
Statements made by judges can be classified as ratio decidendi or obiter dicta.
Ratio decidendi or obiter dicta. Now, these are two terminologies. Okay? And these two terms means that they are some statements by a judge. And these two are different types of statements. Now, number one, ratio decidendi. How are you going to remember this? Ratio means rational. Rationale behind decision.
Okay, logic behind decision.
That is ratio decidendi. Obiter dicta is a by the way statement of a judge. Zahir hai, when we are humans, it's not necessary that the judge is only going to utter the professional and the legal and the holy words of judgment. He might also say, by the way, as a joke, he might say something, he might comment कि आजकल के lawyers को तमीज ही नहीं है बात करने की. It's just a statement and it may be present in the law report. Right? So the reader must know the difference, that what is a ratio decidendi and what is obiter dicta. He must know the difference कि यहाँ पे जज ने फैसला सुनाया और ये जज ने by the way बात की कि आजकल के lawyers बड़े बिगड़ गए, आजकल के teenagers बिगड़ गए. Okay, something like that. He might have passed.
Like one is the fact and the other is just the statement.
Yes. So अब reader जब पढ़ रहे वो तो उस वक्त कोर्ट में नहीं था ना, he wasn't present in the court at that time. He's just reading it, and maybe 100 years back, 100 years after the person has is reading that book, that case.
Yeah.
So the judge, the law must have this knowledge. Next. Please read. Ratio decidendi.
A judgment will start with a description. Okay, ratio decidendi of a case is the principle that a judge follow when coming to their decisions. In other words, it is the reason for their decision.
Clear?
Yeah, clear.
Read from here.
There are two types of obiter dicta, which means something said by the way. A judge statement of legal principles that do not form the basis of the decision. A judge statement that are not based on the material fact, but a hypothetical fact.
So there are two types of obiter dicta. Number one, it is a part of the legal principle, but not the basis of decision.
But if it's a part of a legal principle, then isn't it a ratio decision?
It must, देखो, बहुत सारी बातें बाय द वे की जा सकती है, जरूरी नहीं कि हर बात मैं एक मजाक के तौर पे करूँ। मैं ये भी कह सकती हूँ कि बड़े बुजुर्ग ठीक ही कहते थे कि क्या एक बड़ा अच्छा मुहावरा था।
वो वाला, ये बाल हमने धूप में नहीं सफेद किए,
और समथिंग लाइक दैट के खिलाओ शेर का निवाला देखो चील की नजर से, समथिंग लाइक दैट। सो हमारे बूढ़े बुजुर्ग he might utter anything wise, anything which might be a principle, but that's not the basis of decision. That's not any part of the decision. He might even say something like that. By the way, it can be hypothetical. He might ask a question कि अच्छा अगर तुम्हारा बॉस तुम्हारे साथ ऐसा ना करता तो तुम ये कत्ल नहीं करते।
ओके,
Just to know कि what is going on inside him, and the person might say कि नहीं मैं तो फिर भी करता क्योंकि उसने फलां दिन पे फलां चीज की थी। So the intention is coming out, becoming clear
ओके।
by that question. Okay, so it can be hypothetical, it can be anything which is wise but not part of the decision. Then
Not binding on future cases, but merely persuasive.
persuasive. So obiter dicta are, by the way, words. They are not even binding on the upcoming or the future judges, but they are merely persuasive. बात clear हो गई यहाँ पे?
They are flexible, they can be changed. Yeah.
Distinguishing the facts. Distinguishing the facts is from the point you have to obviously, if you're referring to a case and if you're making that case a basis of decision for your current case, you have to make sure that that previous case has a similar or same facts and figures as yours. So that sense you must have before you refer to any case that has happened in the past. Status of the court matters. If you're a junior court, of course, that decision becomes persuasive. If you're senior court, then that decision becomes
Binding.
binding. Now, court of appeal exception. Now, this is an exception rule. Now, always remember, my dear students, जिंदगी में कुछ भी सिर्फ black and white नहीं होता.
There are always gray areas.
There is always a gray area. You cannot always say no, this is wrong. तो मतलब wrong तो बस wrong ही हो. हर situation में, हर character के लिए, हर चीज के लिए. And
फिर तो we'll become robots, na? Yes and no, yes and no.
yes,
That's it.
yeah, no, it's not. It does not happen all the time. So every law, there is a law. Of course, there's a law to maintain discipline in the public, to make sure that there is no chaos, to make sure that things are happening, to make sure that people are protected, their human rights are protected, to make sure jati zulm ye sab na, theek hai? There is a law, but there is also an exception to the law. And for every law that we are going to study, like over here we are studying the doctrine of judicial precedent. That's the law. So here is the exception that we are going to study.
Yeah.
Same way as we go along the course, the entire course, there will be a law and there will be an exception.
Okay.
You have to know both. Next, Court of Appeal exception. Now, what is this Court of Appeal exception? Kinza, read.
In Young v. Bristol Aeroplane Co. 1944, it was decided that the civil deviation of the Court of Appeal is usually bound by its own decisions and those of what was the House of Lords and which is now the Supreme Court, unless two of its previous decisions conflict when it must decide which to follow. The previous decision conflict with a subsequent Supreme Court decision. The previous decision was made with a lack of care in relation to either a relevant precedent or status or statute.
Okay. क्या कह रहे हैं? अच्छा पहले जरा briefly. Ali, are you there with us? Can you hear us?
Yes, ma'am.
Yes, you have joined late. Everything is all right.
No, ma'am.
No? Okay. It's okay. We have just studied what is judicial precedent, and Kinza will just briefly explain it to you right now.
Okay, ma'am.
Kinza, please explain what is judicial precedent. क्या अभी तक हमने पढ़े? Just brief intro and everything.
Actually, precedent is the previous court decision. What we make, like whenever we are going through a new case is coming up to us, what we will do, we will just go back and look into the history, whatever they have been done with the similar case. So that is precedent, and that doctrine of judicial precedent is the fundament. They are saying that the fundamental principle is the same. It will not change with the time. It will not change, like if the things are modernizing or anything is happening, that's okay. The rules, the laws can be changed. They can be a little bit flexible. The principle would be the same. If one of the thing is wrong, it's going to be wrong throughout the earth is there. So it's not going to change. Like if somebody is stealing something and it's wrong, if you're not protected in a society, if obviously you need protection. So whatever things are there, the principle is always the same. It will not change. It's not like that, okay, now the era is changed, now the things are very modernized, now that's okay, you can take my property, that's okay. So no, the principles are the same. Okay, then there are two things. One is binding and the other is persuasive. Like whenever the case is coming up, so first what we need to see, there are four things which we need to follow. First, the judge will see what this case actually needs some time, or actually is something needs to be done. The other thing is it's RD was ratio dissident, that the case is actually logical. Is it making any sense? Status of the case, where should the case be, which category the case is coming up, and is it comparable? Can we look into other cases to solve this case? So this, and there are two kind of or obiter dicta. Obiter dicta is first is binding and the other is persuasive. Binding is you cannot everything is same. Like for example, if there's a Supreme Court, the Supreme Court has given any decision, so that means it's binding. Now you cannot change because the Supreme Court, High Courts, they are superior. If, like for example, magistrate court has given some decision, then it's persuasive. Then it can be changed. You can reappeal. You can go to the other courts. You can check it out. So that is persuasive. So yeah, this is it.
Okay. So we have done this law, judicial doctrine of judicial precedent, and now we are going to study the exception for this law. And the exception is in Young versus Bristol Aeroplane Company, 1942. Whenever you say CB, you say versus. In Young versus Bristol Aeroplane. Young, who is the claimant over here? This is the name of the
Young.
case. Who is the claimant
Young.
over here?
Young.
Is the claimant, and who is the defendant?
Bristol.
Bristol.
Bristol is the defendant, right? So it was decided that the civil decision, now it's a civil case, civil decision of the Court of Appeal is usually bound by its own decisions. Point to be noted. मैं कोर्ट हूँ, कौन सा कोर्ट हूँ? कोर्ट ऑफ अपील. कोर्ट ऑफ अपील में कौन सा केस आया है? सिविल केस. मैंने एक फैसला सुना दिए, एक केस के लिए मैंने फैसला सुना दिए, 6 महीने बाद सिमिलर केस आया, तो अब मैं 6 महीने बाद कोई डिफरेंट फैसला सुनाऊंगा सिमिलर केस के लिए?
Never.
I'll be bound to give the same decision as I gave 6 months ago for a similar case. That's what it means. Court of Appeal is itself bound by its own decisions, and those of what was the House of Lords and which is now the Supreme Court. So एक तो वो अपने फैसले पे बाउंड रहेगा की वजह से बाउंड रहेगा, एंड दूसरा सुप्रीम कोर्ट के फैसले से. सुप्रीम कोर्ट वाज आल्सो नोन एज हाउस ऑफ लॉर्ड्स बैक देन. Okay, so they will be also bound by their decision. Now there are few conditions as well, exceptions, and the exception is that unless two of the previous decisions conflict, I am Court of Appeal, and I am bound by the decision which I took 6 months ago for the similar case.
Yeah.
Is it clear till here?
Yes, ma'am.
Is it clear till here? Exception
Yes, ma'am.
exception is that I will not be bound unless there is another similar case जिसमें मैंने कोई और decision लिया हो. That means two of my decisions are conflicting each other. For similar cases, if two of my cases are conflicting each other, they are conflicting each other. One is saying yes, the other is saying no, and both are the similar cases, then I am not bound by either of them. Then I have to decide again that, okay, what is right and what is wrong. I have to check out the principle and the investigation and so on and so forth. ऐसा हो सकता है?
But ma'am, you were saying that you are bound to make the same decision. So how can
Yep.
the cases conflict?
That's the general rule. I am bound. That's the general
Yeah.
rule. Exception is, that is why this is an exception.
Okay.
That is why this might happen in which scenario, Kinsa? That's what I'm asking you. Do you think this is possible? Do you think it is possible? And do you think that
Well,
if it is possible, then in which scenario? What are the reasons behind such a situation?
I think it is possible because maybe one time we are just giving up a decision and later, according to the situation, we think that no, this is now getting something very serious. The society is getting very non-serious about this rule, so I should better be very firm about it. So next time you are giving the other decision.
It might happen early. Any other possibility?
No, ma'am. If the scenario is different, maybe that's why a decision should be changed.
Similar
Otherwise,
facts, similar case. Only
no, ma'am. I don't think.
Because
I
sometimes
don't think.
media gives a lot of coverage to a specific case, so later there is a lot of pressure on the court, so they change up the laws, and sometimes they
that is
change up
another
the
possibility. So you gave
yeah.
two possibilities.
Hmm.
The third possibility could be that judge ही बदल गया हो. कल मैं जज थी कोर्ट ऑफ अपील की, आज कोई और है. तो मैंने जिस तरह रूल को इंटरप्रेट किया और जो डिसीजन दिया वो दूसरा जज शायद बिल्कुल डिफरेंट तरीके से करे.
True.
So this is how cases might conflict each other. Two judgments, two decisions might conflict each other, and then फिर आगे चल के they might think themselves that okay, now which one to follow.
Yes.
Okay, next.
Okay.
The previous decision conflicts with a subsequent Supreme Court decision. This is the second exception.
Yeah.
A case has come to me, I am Court of Appeal. I know the principle, I know the law, I have passed it accordingly, I have given correct decision. This case goes away, fine, finished. A similar case arises in the Supreme Court just a week later. Or maybe just a month later. And same case, same scenario, Supreme Court passes a different kind of decision.
Yeah. So now you need to follow Supreme Court's decision, not yours.
Yep.
For further cases like.
Now it's just conflicting each other, right? It is conflicting each other. So do you think the Supreme Court is bound to listen to Court of Appeal?
No.
To make
No.
as per the Court of Appeal?
No.
No, ma'am.
They are persuasive. Yeah.
That's
because they are superior from the other courts.
Third exception. The previous decision was made with a lack of care in relation to either a relevant precedent or statute. The previous decision was made with a lack of care in relation to either a relevant precedent or statute. What do you understand? Ali.
Okay, I think.
Yes, ma'am. There was some loopholes which the previous court didn't follow while making decision, and there was some cases similar to the this case, which the case like observe while making decision. This is what I get.
Okay. Okay. You can say that there might be some loopholes, but usually the law is a holy law, is legal. It cannot have any loopholes. Okay, so the
Okay.
problem lies either with the judge himself, because he is human and human makes mistake.
Yeah, and sometimes, ma'am, like if you talk about child custody, they were not very concerned about it. They were taking it very easily.
Right.
But now, as you see, the children are going abroad, and the mothers or sometimes father are taking them away. So now, recently, there are very strict laws about this child custody stuff.
True.
So I
Due
think
diligence. You can say.
And lack of care can also mean that it might happen that the judge was not in his senses when he came on Monday morning to the court. Hung up. Right?
Happens.
exactly.
Right.
That is possible as well. So these are the few exceptions. Now, it is important to learn the operation of the court hierarchy as we did the structure of the court and how courts are bound. It is important. Okay. To learn the cases, learn the case names, not important. Case dates, not important. Case story, yes, you should remember it because the story will help you to remember the law. And the story will help you to remember the law, then you will be easily remembering the exception as well. Okay, so next, persuasive precedents. Okay, we have discussed this, persuasive and binding. You can go through this yourself. Avoidance of a binding precedent. What is this avoidance of a binding precedent? That means a precedent of an old case. Whenever you hear this word precedent, an
Precedent.
old case. Binding. Binding, you're forced to take the similar decision as the previous case. When? Kinza, when are you bounded by the decision?
We are bounded when we are not we are inferior, when we have to, like, we are bounded if we are in a supreme court, we are a superior court, then we are persuasive, we are
If
not
the
bound.
old case has happened in the senior court, then we are bound to follow. If I am a junior court and the case I'm referring to is of a senior court, I'm bound to follow.
Yep.
Right? That means
Right.
binding precedent. Plus, if the facts are similar, plus if
Yeah,
I
the
know
case
that
is scenario is similar, the case is
scenario
similar,
is
so I
similar,
have to follow what previous judges have made the judgment.
exactly.
Yep.
Now, what is this? How and in which scenario can I, being the court of appeal or being a junior court, can refuse or avoid to follow that particular case decision which I'm referring to, and it is also happening in the senior court and everything is right. But what could be the circumstances where I, as court of appeal, can say, no, I'm not going to follow?
When there are exceptions.
So read, Kinza, first point.
It may be able to distinguish the fact.
Okay. That means
that we can totally see the fact very clearly.
that the case is different, the facts are not matching,
Right.
right?
Yes.
Next,
Right.
Ali, next one.
It may declare the ratio deciding, T obscure, particularly when the Court of Appeal decision by 3 of the 5 judges has many reasons for the decision.
What does this mean? What do you understand? Kinza, can you explain it?
They're saying if the case is done with the logics, with a rational decision, it's not something with just they're just following the statement. If it's a logical statement and some of the main judges, some of the main 5 of the judges are giving the reasons about it, so then of course, then you can avoid it, then you can change the
Saying
decisions.
opposite. You are saying opposite. Ratio decidendi, ratio means rational,
Right.
reason.
Rational.
Decidendi means decision. Reason behind decision or rationale behind your decision is obscure. Obscure means it's not clear. You are
Not
unable
clear.
to
Wait.
understand. You're unable to get the logic behind this decision.
Okay.
And particularly your court of appeal. Okay. Particularly the court of appeal decision by 3 or 5 judges gives as many reasons for the decision, but you are not getting that decision. It's not clicking.
And I'm not convinced.
You're not contented with the reasons. It's not clear the reason, the logic. So you may avoid on that basis.
Okay.
Next, Kinsa.
It may declare the previous decision made per incurium without taking account of some essential point of law, such as an important precedent. They have missed something. They have missed one of the. They were actually going to the previous decisions, but they have missed one of the very important, because there are a lot of court decisions in the past, not only one, but they have just gone through the other non-serious ones, and they have missed something very important case.
Yes, exactly. They have missed something very, very important. Some maybe a very important, famous old case where similar facts were there, and they might have just, forgotten to take that into consideration. Next point, Ali.
It may declare it to be in a conflict with a fundamental principle of law. For example, where a court has failed to apply the doctrine of privity or contract, Baswick versus Baswick, 1968.
Right. So what are they saying, Ali?
They are saying that whenever the law is being conflict in the decision, so the court can like ignore it.
If it is in
Like the
conflict
case
with the
of Baswick.
fundamental principle of law, fundamental, very basic rules of law, very basic.
Yep.
So therefore, they can say that, okay, we are not following the same decision. Like they have given an example where a court has failed to apply the doctrine of privity of contract. Now, what is this doctrine of privity of contract? Hold on this. We are going to understand this in upcoming chapters, okay? And this is just a reference to a case, Beswick versus Beswick, which we will be studying when we will understand privity of contract. So for now, it is enough that if there is a basic fundamental principle of law which has been ignored or nullified or not being followed, then the court can say that sorry, we are not going to follow the decision made by this particular court in this particular case. Next. Kinza.
It may declare an early precedent to be too wide. For example, the duty of care to third parties created by Donge versus Stevenson in 1932 has since been considerably refined.
ऐसा possible है कि पुराना केस जो है it's talking or it's giving decision which is very generalized or it's too wide. It's becoming vague or it's not specific. So it might happen. So we will be studying many cases in the upcoming chapters. We will be looking at these points. So these were the 5 points. Next, advantages, disadvantages. Go through it yourself. Now, so the first source is done. The first source of law was doctrine of judicial precedent. What is the first source of law?
Doctrine of judicial precedent.
Judicial precedent is the first source of law. पुराने cases. पुराने judicial cases हमारे लिए एक source of law है. पहला source है. दूसरा, legislation. What is legislation?
Legislations are the rules, the written rules.
Ali.
The legal written rules.
What's the difference between
legal rules?
Judicial precedent and this legislation? What's the difference?
The judicial precedent is the case we're just going through, we are referring, and we just want to get idea, and then we are applying. But legislations are the exact rules that we are following. The written rules, what are written, and we have to follow.
Ali?
Legislation can be like black and white rules, and like previous cases, there would be some changes made to the like black and white rules as per the case.
See, precedent are the cases happening in the court, happening by the judges, decisions taken by the judges, proper court system. Legislation, laws are being written in the parliament. That's the difference.
Laws are being
written in the parliament. State is making it. State is taking a decision on particular, problem areas of the society, and they are making laws as per the solution. Okay.
Like if the new laws are coming up, Only then it's going to be there.
Maybe new laws, maybe old laws, it all depends, but it is happening in parliament. Maybe modifying the old laws, but whatever it is happening inside the parliament. Okay, that's legislation. So Ali, please read the definition.
Okay. The second major source or law is legislation. This is also known as statute law and may take form of acts of parliament or delegated legislation under the acts.
That's it.
Statute law is made. Hmm.
So what is it? Statute law. And it is known as laws made in the parliament is known as acts. What is it known as? Acts.
Act.
Okay.
Acts.
Now moving ahead. This is another source from where we can refer to those discussions that are happening in the parliament and the arguments for and against. Like for example, COVID came. What do you think? The COVID laws were made in the court or in the parliament?
Parliament.
Parliament.
They were discussing that what should be done. It's a global pandemic. What kind of laws needs to be issued in the public? Stay home, lockdown. That was from the parliament. Nobody is supposed to step out. All offices, workplaces, schools, hospitals, all closed, shut down. The end. So the court, the judge can refer to the discussions happening in the parliament for, against. How many people were for the lockdown? How many people were against the lockdown? What other solutions were suggested? What was the medical team discussing? What was the education team discussing? What was happening exactly? What are international parliaments discussing? What is happening on a political level internationally, globally? What kind of rules? What vaccines? What so on and so forth. Now, parliamentary sovereignty. What is parliamentary sovereignty? Can I read?
Parliamentary sovereignty gives a rise to a number of consequences. Parliament may repeal earlier statute.
Okay, point number one. Point number one. Parliamentary sovereignty means what? Parliament के पास कितनी power है, कितनी authority है, क्या कुछ कर सकता है, ठीक है? So there are a number of things that a parliament can do. Number one, repeal earlier statutes. Parliament change होती रहती है. Every 5 years the party changes, somebody else comes and rules. So they might change earlier statutes. They might change earlier laws made in the parliament by the old parties. Yes or no?
That's what
Yes.
they do, ma'am.
That's what we do. They can overrule or modify case law developed in the courts. They can even do that. They have this much power.
Yeah.
Exactly.
And the third, they can
Make new law on subjects which have not been regulated by law before.
make new law on subjects which have not been regulated by law before. COVID कभी भी पहले नहीं किसी के भी country के हिस्से में नहीं आया. Right? It was first time ever that each and every country was facing this new kind of virus called COVID virus. COVID-19. Next, in practice, Parliament usually follows certain conventions which limit its freedom. अब वो तो पार्लियामेंट को इतना ज्यादा अथॉरिटी और फ्रीडम मिल जाएगा तो वो तो कुछ भी कर सकते हैं, किसी भी तरह का लॉ बना सकते हैं. So there has to be some restrictions as well. And what are those restrictions? Number one, no parliament can legislate so as to prevent future parliament changing the law. If
Okay, they cannot. They cannot hold it. Future parliament can always change the law.
correct, they cannot make such a law which will restrict any future government.
Okay.
Judges have to interpret statute law. Judges को statute law interpret करना पड़ेगा कि what was the context, in what conditions this law was imposed, what was the objective behind it. लॉकडाउन का लॉ सिर्फ कोविड के सिनेरियो में था, पैंडेमिक के लिए. क्या अभी कोविड खत्म हो गया? नहीं ना. तो क्या वो लॉ अभी भी लागू है लॉकडाउन वाला?
नहीं.
No.
So interpretation must be done very carefully. They must find a meaning in it which those who promoted the statute did not intend. They may find, because judges might find another meaning to this. Na lockdown, okay, lockdown can be done. We can lock down the country whenever we feel like.
Hmm.
We cannot lock down the country whenever you feel like. It was a pandemic and it was a deadly virus which was contagious and people were dying. And that is why this step was taken. Otherwise, you can't just lock down the entire the world without any, proper valid reason.
Yeah.
Next, third, validity of an act of parliament cannot be questioned. You cannot question, "ये भाई ये law क्यों बनाया भाई?" You cannot do that. Parliament has the power. It cannot be questioned. However, judges may declare an act to be incompatible with the European Convention on Human Rights. देखो जहाँ पावर दे रहे हैं पार्लियामेंट को वहाँ कोई रिस्ट्रिक्शन भी होनी चाहिए, नहीं तो वो गलत इस्तेमाल ना हो जाए पावर. तो रिस्ट्रिक्शन क्या है? Judges can control. Judges can question. Judges can say that okay, this particular law is against the human rights. You cannot impose it. Sorry.
But ma'am, on one side they are saying they cannot be questioned.
They cannot be questioned by the public. They cannot be
Okay,
questioned by
only by the judges.
anybody. However, judges have that power. The court has the power to question.
Okay.
To declare an incompatible act with the European Convention on Human Rights. You remember the court structure. After all the court structure, there was a European Court of Human Rights. For the
Yep,
entire
European Court of Community.
that
There were two
court
European.
can question. That court can question. It has the authority. It has the power.
Okay.
Okay. Types of legislation. What types of legislations can come into existence? Number one, public acts. Number two, private acts. Number three, enabling legislation that empowers a specific individual or body to produce the detail required by the parent. Public act, law for the public. Private act, law for the particular industry, particular company, particular individuals or groups. There are particular laws for import-export companies, right?
Yeah.
That is not applicable for the entire public, but only for those companies who are doing import and export, right or wrong?
Right.
Same way, now enabling legislation that empowers a specific individual or body to produce the detail required by a parent. For example, the parliament has created an act, okay, a law. It is passing a law, okay. Now that law, maybe somebody needs an explanation to it, that what was your logic behind it? Why are you introducing this law? Why are you introducing this law specifically for this industry, for textile industry? Why not for other industries? Why are you making this, you remember the COVID days, everything was open, the markets, the restaurants, the offices, but for schools. Schools were not.
Yeah.
Schools were not allowed to open. They were locked down even after we came out of the emergency situation.
Yeah.
For so many days, so many months, right? So
Yeah.
the education body, the schools can question that why. Can they or they cannot?
Yes, they can.
They will ask, they will say, they will talk, they will have the debate. They will say that, okay, let us open our schools. Children are getting, insane at home. So the parents, so let us open the schools. We will take precautionary measures. We will wear masks. We will make sure they are vaccinated. We will make sure that they sit one chair, they leave the space in between, 6 feet gap. We will ensure that, okay, there will be alternate days of school, one day off, one day online, one day they will come on site. There were so many things that was happening that time, but that was only restricted to the education industry.
Yeah.
Zombies were coming into existence.
So true, so true. Okay, next. Parliamentary procedure. What's the parliamentary procedure? Yes, Ali, read.
First reading. Stage 1 is first reading, publication, and introduction into the agenda. No debate. First, we are just going through what is actually happening. We are not debating. We are not arguing with anyone. So it's just making up the points
Let's
in
take
some
this
way.
example now of the COVID. COVID आ गया, पहली दफा आया है COVID और ऐसा सुनने में आ रहा है कि इटली, यूरोप सब बंद हो रहा है. Now what is going to happen in the Pakistan Parliament? First reading, stage 1. This is not about Pakistan Parliament. This is about the UK Parliament. Okay, so we are just assuming that okay, this is COVID scenario has come and it has first struck China, and then the Europe, and then it's coming to the Asian countries as well. So now what to do? First step, first reading. Problem क्या है? मसला क्या है? क्या हो रहा है globally? अच्छा, क्या facts and figures आ रहे हैं? First reading. Second reading.
Okay. Debate on the general merits of the bill. No amendments at this stage.
Okay, what is the solution being suggested in the second reading? What is the solution? COVID आ चुके हैं, उस कंट्री ने ये कर दिया, लॉकडाउन कर दिया, उस कंट्री ने वैक्सीन के ऊपर रिसर्च शुरू कर दी, फलानी कंट्री में इतने लोग मर गए, हमारे पास क्या सॉल्यूशन? So what law should be passed in our country? अच्छा, लॉकडाउन का प्रपोजल आ रहा है, क्यों? क्योंकि चाइना ने भी लॉकडाउन कर दिया, क्यों? क्योंकि यूरोप ने भी लॉकडाउन कर दिया, so हमारे पास भी लॉकडाउन प्रपोजल है. What should
Okay.
Let's debate on it. अगर लॉकडाउन करते हैं तो क्या फायदे हैं, लॉकडाउन करते हैं तो क्या नुकसान हैं? Okay, just discussions. Next, third
Okay.
stage.
Committee stage. The bill is examined by a standing committee of about 20 members, representing the main parties and including some members at least who specialize in the relevant subject. If the bill is very important, all or part of committee stage may be taken by the House as a whole sitting as a committee. Okay, now they're making up some committees who are actually specialized in that specific matter.
What kind of committee will be set over here in this scenario?
Yes.
Doctors,
Yes.
scientists, economists,
Exactly.
and
Especially the people who are coming from the health industry,
And
especially
the traders as
from
well.
scientific industry, research centers where this particular virus is being studied. Okay, so the committee will be set. But this is such an important issue, and this is a global issue that do you think that the entire parliament has to sit down and think about it?
No.
no, I don't think so. The entire parliament, but the specialist
Like
people.
like a percent of like specific percentage of the parliament should be sit there, I guess.
Right. So that is the report committee stage where you are the specific experts are sitting, giving their opinions, and also if it is a very important issue of an international importance, then the parliament important key members will also be sitting. Right. Next, stage 4, report stage.
The bill as amended in committee is reported to the full House of approval. So now they're making up they are just amending up the bills, and now they're reporting it to all of the committee members, the full House, so that everybody can approve and they can proceed.
After the committee has made the investigations, studied upon it, thought about it, merits, demerits, discussed, okay, सबकी राय ले ली गई है, रिपोर्ट अब बना चुके हैं, रिपोर्ट अब प्रेजेंट कर रहे हैं कि ये फाइनल रिपोर्ट तैयार है कि हमने ये इन्वेस्टिगेशन की, ये उसके एडवांटेज निकले, ये डिसएडवांटेज निकले, अब एक है यस या नो, पास करना है बिल या नहीं करना. सोल्यूशन है कि लॉकडाउन फॉर 90 days. Voting will happen. People will either say yes, it should be locked down. People will say no, not locked down. जो ज़्यादा votes आएंगे या जो approval हो जाएगा, then in the third reading, the final approval stage, it will be announced, the law will be passed, signed, and ordered to be executed and implemented.
Okay.
Done? Clear?
Good. Done.
Advantages, disadvantages, go through it yourself. Delegated legislation. What is delegated legislation, Kinza? Any idea?
Delegated means that they are just distributing up. They are delegating the, like for example, if they are making up some laws regarding medical things, so they are delegating it to the special team, and they are making up the laws, not the economists. So they are delegating the legislation to the right people.
Right. अब obviously बात है, पार्लियामेंट में जिन बंदों ने ये लॉ पास किया, they are not going to go into the streets and into the people and make them shutter down, karo,
Follow the rule.
बैठो, lockdown.
Exactly.
They're going to do that, right? They're going to pass on the responsibilities, and they have announced, they have done their duty. Now it's the duty of the other people who are there, who are in charge, and who will be taking the authority and making sure that it is right? So that is delegated. Delegate the responsibility, the authority down the line. Okay. Next, so I think you guys can read through this, and I hope you will understand this, right? Control
Right.
over delegated legislation. You can go through it. Disadvantages, advantages. So now the third source of law, statutory interpretation. What is statutory interpretation? Okay, I would like you guys to read this statutory interpretation. Okay, this para that is there on the screen, and then you explain it to me what it is all about. Okay, so I'm just giving you 2 minutes to go through it. You can even just get some water for yourself, take some break.
Okay. Legislation must be interpreted correctly before judges can apply it purely. Literal, gold, and mischief rules of interpretation developed over time. Nowadays, a proposed approach is taken. These are also faced with the task of applying legislation.
G. Are you guys done?
Yes, ma'am.
Right. So, क्या समझ आया? Statutory.
Yes, ma'am.
Ali, I want you to start. Ali, I want you to start.
With reading, shall I read it or elaborate it directly?
Explain it to me. Explain what you have understood.
Okay, like like uh, there can be a difference of level of understanding of the judges. So the decision could be changed in some cases. For example, first one is ambiguity. If there is a law and a law has some wordings which has more than one meaning, there are some synonym that can be used, and so one judge can interpret it in either way. And the second one is uncertainty. Like where is like there is a lot of uncertainty in law. For example, uh, I didn't get this point. Third one is unforeseeable developments, and the fourth one is broad term. For example, in some cases, Ajay said if someone uses this vehicle, he should be punished. So there is no specific explanation which sort of vehicle. So vehicle is a broad term. Anything could be a vehicle, a motorbike, a car. So there should be specified explanation to that. So if that is not the case, then there could be misinterpretation.
All right. That's great. Kinza. Kinza,
Well,
have you
ma'am.
understood the first point, ambiguity?
Yes, ma'am.
All right. So this is understood by Ali as well. It has dual meaning. It is not clear. It might have an error in drafting. Okay. It's uncertainty. Can you explain uncertainty?
Uncertainty is that the situation is not always the same. Sometimes the factual information we are just following for one situation, and it doesn't mean that it's going to be the same every time. So it's an uncertainty. The things are vary. The things and situations vary.
Right. Uncertain, you don't know. COVID was unforeseeable. We never knew that's going to happen. So uncertainty is always there. Even when you are making laws, for example, the parliament said lockdown, it could have backfired. People could have come out on the streets and said, no, we deny the lockdown. As it happened in some countries, after a few months, they were so frustrated, they all came out on the roads. But forget about lockdown. We are all in one. We all get COVID. It's okay. Okay, but we are frustrated at home. So there's uncertainty that how people are going to react to that particular.
Yeah.
You never know it can backfire. Next, unforeseeable event developments.
Obviously, future cannot be seen. We cannot be 100% sure about what is going to happen with our decisions.
Same
So they are
or
unforeseen.
similar explanation, right? And broad term is rightly explained by Ali. It's fine. Okay, now there are a number of different sources of assistance for a judge in their task of statutory interpretation. That means if you want to interpret a law, there are some yardsticks to help you do the right interpretation. And what are those? Number one, rules. Number two, presumptions. And number three, aids. Rules, presumptions, and aids. What are these? And what are the examples? We will be doing it in our class tomorrow, inshallah, because this is again a detailed and in-depth. So I would like you guys to have some fresh mind to understand. It's quite a long chapter, I know. So there are only three topics, three sources of law, but yet you can see so much of detail, right? Ali, any questions till now? You joined us late,
No, ma'am.
so you have to catch up with the recording. Okay.
I'm gonna reread it and let's re-listen the starting 1 hour, and then gonna ask you if there is any confusion.
Right. Kinza, any query?
No, ma'am. Everything's clear.
All right, your days for your classes are Monday to Friday. Please note it. Okay, it's Monday to Friday.
Okay.
It's not Monday to Thursday.
Okay.
Okay. Thank you so much. Signing off for today. Allah Hafiz.
Okay. Allah
Allah
Hafiz.
Hafiz. Thank you so much.